That concludes questions for oral answer. I call on Government Order of the Day number 1.
Taxation, Land Information and Offshore Persons Information Bill, first reading.
The Honourable Louise Upston.
Thank you, Mr Speaker. I move that the Taxation, Land Information and Offshore Persons Information Bill be now read a first time. I nominate the Finance and Expenditure Committee to consider the bill. At the appropriate time, I intend to move that the bill be reported by Monday the 17th of August 2015 and that the committee have authority to meet at any time while the House is sitting, except during oral questions, and during any evening on a day in which there has been a sitting of the House, and on a Friday during the week there has been a sitting of the House despite Standing Orders 191 and 194, 1B and C. Mr Speaker, this bill will authorise some of the measures announced in Budget 2015. The package of measures will ensure that people buying and selling residential property for profit, including overseas buyers and short-term speculators, pay their fair share of tax. It will not unfairly impact New Zealand owner-occupiers who have worked hard to buy their family home. But it will help enforce the perfectly reasonable and fair expectation that anyone who has obligations to pay tax in relation to their property should pay that tax. That is in fact the current tax law, and it applies equally to New Zealanders and overseas buyers. However, this law has been difficult to enforce, and that is what we are here to change. Mr Speaker, this government is committed to ensuring fairness by pursuing those attempting to avoid paying tax. This bill will give Inland Revenue the information it needs to enforce the rules. From the 1st of October, all offshore investors and New Zealand residents buying or selling property which is not their main home must provide a New Zealand Inland Revenue number as part of the land registration process. If a person is resident for tax purposes in another jurisdiction, they will also have to provide the tax identification number or TIN number issued to them by that country. This will help Inland Revenue identify people who are trading property for the purposes of making gains in the New Zealand market. And it will allow us to provide information to overseas tax authorities in line with existing New Zealand legislation, ensuring taxpayers' compliance with tax obligations both in New Zealand and overseas. Under this legislation, conveyancers will collect tax information from purchasers and vendors of property as part of the conveyancing processes prescribed by the Land Transfer Act 1952. Property vendors and purchasers will be required to provide their IRD number and, if applicable, the equivalent overseas IRD number, and in doing so prepare and sign a statement affirming that the information they have given is correct. Conveyancers will be required to provide this declared tax information before certifying the property transfer. Conveyancers will not be required to certify the accuracy of the information provided. The onus, Mr Speaker, will be on the purchasers and vendors to provide accurate information. While those buying or selling their main home are exempt from the tax information requirement, the legislation will require trustees to provide the trust's IRD number. People have a choice regarding whether they hold property through a trust, and we think it's preferable from a simplicity and integrity perspective that trust always provide an IRD number. All of this tax information will go to Land Information New Zealand, or LINZ, who in turn will provide the information to Inland Revenue. Tax information provided to LINZ is personal information. It will not form part of the Land Transfer Register administered by LINZ, and individual taxpayer information will not be publicly available. However, Mr Speaker, the bill does make provision for the publication by LINZ of aggregated information relating to the tax residency of persons undertaking property transactions. For example, statistics describing the relative number of transactions by persons who are tax resident in other countries compared to those who are not. This will not be the same as a register of foreign ownership, because there are many New Zealand citizens who are tax residents of other countries, but they are not foreigners. but the collated tax residency information will provide useful additional layer of information to inform debate about property ownership in New Zealand. We are serious about these measures, and for those who knowingly supply false or misleading tax information, there will be stiff penalties. Under the bill, it is an offence to intentionally provide false or misleading tax information. Any person convicted of this will be liable to a fine not exceeding $25,000 for a first-time offence or $50,000 for subsequent offences. Mr. Speaker, regulations will be made to describe land transfers and parties that are exempt from providing tax information in addition to the main home tax exemption. Such exemptions will only be made where the requirement to comply is impractical or involves high compliance costs or where there is a low risk of tax avoidance. Here's another key point, Mr. Speaker. This legislation will mean that before being issued an IRD number, offshore persons will need to have a New Zealand bank account. This means that any offshore person looking to obtain an IRD number will first be subject to New Zealand's anti-money laundering rules. To avoid offshore individuals circumventing the rules by using a New Zealand company or trust, the offshore person definition also includes look-through rules from the Overseas Investment Act to treat New Zealand trusts or companies as offshore that are owned or controlled 25% or more by offshore individuals. That prevents a situation whereby, for example, shares in a New Zealand company with an IRD number are sold to an offshore person to avoid the application of the rule. The bill also obliges a person other than an individual to provide a bank account number in the event that they become an overseas person at a later date. That prevents a situation whereby, for example, shares in a New Zealand company with an IRD number are sold to an offshore person to avoid the application of the rule. Mr. Speaker, this government is committed to ensuring fairness by pursuing those attempting to avoid paying tax. The public will have an opportunity to comment on legislation through the Select Committee process. However, in order to have this regime in operation by the 1st of October, a shorter than usual Select Committee timeframe is necessary. In particular, it is imperative that we align implementation of these measures with the Bright Line test announced by the Government in Budget 2015. The Bright Line test will require income tax to be paid if a residential property other than the seller's main home is bought or sold within 2 years. The Bright Line test will apply to properties brought on or after the 1st of October. The early report back date will ensure we can have in place the regulations that are necessary to support this legislation by the 1st of October. As I mentioned a moment ago, these regulations will describe land transfers and parties that are exempt from providing tax information in addition to the main home exemption. These measures being introduced by this bill will assist with the enforcement of tax compliance rules without unfairly impacting investors buying with a long-term view of renting their property to tenants or New Zealand owner-occupiers who have worked hard to buy their family home. Mr. Speaker, I commend the bill to the House.